As I look upon my life, in the shadows, there's a passion inside. Heaven knows I'm living my dreams. As I look upon my life, in the shadows, there's a passion inside. Heaven knows I'm living my dream.
Good morning, everybody. Yay, greetings to you on this beautiful autumn morning, a Thursday morning with Talk with Joan Thursdays. And so we want to welcome you. Tune in because we know we are dealing with a very important topic here this morning, and it is a dreaded topic. People don't want to talk about it, and it's not that when we talk about it or when you have to do it that you're gonna die tomorrow. Man. No. So we have to talk about these things, so that you can be prepared for the future and for the days to come. So we have important people in the studio here with me. They are not strangers, by the way. My guest actually is becoming one of the ladies that will be with us every now and then, guys. Yes. So we will get her back every now and then when we need to deal with a topic that we have to have an attorney. Yeah. We are so happy and so grateful that God actually made this possible. Yes. Things happen for a reason. Yeah. When we meet each other, there's a reason, there's a purpose. And I believe in that. And so, we have with us once again our advocate, which is Diane Peters, and she's going to introduce herself, and then we're going to ask our co-hosts just to introduce themselves. You know them, but it's like just to say hi there, how are you doing? Listen, guys, if you did not subscribe as yet, come on now, man. Come on. Just hit that bell and subscribe so that you can know what is happening on the Inside Show, because it's not only on a Thursday, it's every day, guys. And there's a lot of, and you know what? There's interesting topics with the younger generation, right? The Gen Zs, they actually have very interesting topics. They follow trending stories, things that I don't know anything about. So, I'm going to listen to them when they talk, and that brings us into the loop of what is happening in this world today. So I'm going to ask Diane just to introduce herself, and then we're going to go over to Leanne and to Violet.
I'm going to keep it short because I think everybody knows me by now. Diane Peters Krill. Yes, I am Krill also because I'm married. Yeah, somebody eventually took me, thank you. I was gathering dust on the shelf. But yes, I'm an attorney practicing in El Dorado Park. I'll keep it short for now. Yes. Yeah.
Hi, everybody. Welcome back to the Inside Show. Please do what you need to do. Follow us, subscribe, and like. And I think comments in this regard will also be very interesting. We are excited to have this conversation. Wills and testament can be taboo, but today it's going to be good. And I'm so glad to meet Diane for the first time, and also just to chat with her and pick her brain. And I would have taken you if you're still on the market.
Oh, I love that. Good morning, everyone. My name is Violet De Beer, and I'm excited to be on the Inside Show this morning. The topic that we are having, discussing this morning is very close to my heart, and because I feel knowledge is power, and that we need to be empowered. So I'm looking forward to picking Diane's brain this morning and just getting every bit of knowledge out of her.
Yes.
So thanks. Whatever you're doing, just drop it and just listen this morning.
Absolutely.
Okay.
Right, so now you have it. You know the people on the show right now, so that gives you the liberty to just talk to us via YouTube. So you can actually, we'll read your comments. If there's a question, please ask the question. And if Diane can, she will be able to actually answer the question for us. So we have a lot of questions. We're going to bombard her with questions here today.
Bring it on.
Yay,
Bring
come
it
on out. I'm so happy. So yes, beloveds, thank you so much for tuning in this morning. Thank you to Bernice Boysons. Thank you for Denise Peterson, our familiar.
Our familiars are on
Gail, Gail is on. Thank you, Gail. Sandy Edwards, thank you, friend. Thank you so much for tuning in. We know we're going to have a good time here this morning. So, yes, let's go, Diane. I first and foremost want to ask you, today we're not going to do the mirror because there's such a lot that we have to actually talk about.
Right.
So I'm not even going to waste time on anything else. So we're going to go into the topic straight away.
Yeah.
So our topic this morning is estates and wills.
Yeah.
And I know that a lot of people don't want to talk about wills, don't want to talk about estates, you know. They totally
Yeah,
it's a
move
taboo
away.
topic.
It's a taboo topic,
Yeah.
right? They avoid the topic because people think that if you have a will or you have to actually draw up a will that you're going to die tomorrow.
Ja.
Nee.
Ja.
Ons het so gesê,
Ja.
het gaan nie so wees nie.
Ja.
Ja, dis eintlik baie belangrik vir jou
Ja.
om 'n will te hê
Yes.
en 'n testament.
That's it.
Dit is van fenominale belang.
Oeh.
Jy moet.
Hey, die Afrikaans.
Is van kardinale belang.
Dis van kardinale belang.
Yes.
Absoluut so. So yes, Diane, first and foremost, if you can just explain to us and break it down, first and foremost, what is a will and what is an estate? So we can get the difference between the two. Is it the same thing? Is it a different thing? What is it? Because some of our elderly people, they hear you must draw up a will, but they don't really know what it is, you know. So I actually want to, because this is an insight show, we want to give insight, right? What is a will and what is an estate?
All right, so basically, I'm going to start with an estate because I think it will make sense. An estate is any property that you acquire.
Okay.
You know, that is building your estate ultimately. I'll make the simple example. If I get married to somebody, what is the main goal? It's to have a house. You have cars, you have pension funds, or whatever the case may be, all right? So that is basically your estate.
Yeah.
Everything in the estate is basically the movable property. It's your pension, it's your investments and all that, right? Now, what is a will? A will is a document drawn up by an attorney or an accountant or anybody who obviously knows how a company, wherein you actually say how the property should be transferred, or, you know, who should inherit your property, what must happen in the event of death.
Yeah.
So it's absolutely essential that you have a will.
Yeah.
If you're older than 16 years old, you can, if you have any property, or, you know, you can start to then draw up a will for yourself. And it's very important. A will has certain requirements. So that is why it's so important that the expert draw it up, because if it's drawn up wrong, there will be consequences. The will be rejected.
I like the fact, Diane, that you said if you from 16 years old.
I also.
That
also.
just struck me now.
Yeah.
Which means that, you know, normally we think that a will and or testament, and maybe you can tell me what's the difference between a will and a testament, is only for older people. So for me, you know, before, it's when you get older, when you're a senior citizen, then you need a will.
Yeah, it's that
Is that true?
It's that
Or is that a
association
myth?
with death and
Yeah,
wills. It's
death
like,
and
if you get old, you're gonna have you at risk of dying, so you should have a
Right.
will.
Yeah.
But it's more than that, I think, because you don't only get the will now, which is your last testament, you also get estate planning, which
Right.
means that it's something that you can consciously think about while you are still alive.
Yeah.
Like the way you manage your affairs is something that you should think about while you're alive, and that obviously does have a bearing as to how it affects your will and, you know, the dissemination of your assets and your things. And yes, I also like the fact that you can draw up a will at 16, because
16.
nowadays the only reason why you need a will is because you have stuff, and children
Yeah.
have stuff
Yeah.
a whole lot
That's it.
earlier than they
Yeah,
used
that's
to.
a fact.
Stations, you
Yeah.
name it.
Yeah.
And also not that we're just out of COVID.
Yeah.
You know, and a lot of children lost their parents.
Yeah.
So they actually maybe inherited
That's
things. And at the moment, maybe an uncle or an aunt is living with them, or they live with them.
Yes.
So, but they still, you know, maybe the parents left that inheritance for them, you know. And most of the times we find that in our cultures, you always find that there's someone who's after
The money.
whatever is left, you know, for the
let's-
children.
yes.
And I think it's so important then for the children actually to know what it is, because tomorrow after tomorrow, they grow, you know, they become adults, and they actually need then whatever was left for them. And then most of the times, our children are left alone, and someone else got the benefit of what was left for them. You see what I'm saying?
That's so
Yeah.
It
dangerous.
happens every single day. We see
Yeah.
it happening.
Yeah.
And it is so sad.
I think
But
COVID
go
just
back to your question though. You asked what is the difference?
Testament,
between,
yeah.
You wanted to know.
yeah, the difference between a will and a testament, and then also the importance of a young person. And I'm thinking mainly about, you know, my daughter that's young with a husband and has 3 children, who's going to look, you know, if she wants me, she said she wants me to take care of
Yeah.
the children. Will I be fit enough? Will I be old enough?
Yeah,
You
yeah.
know, what should young people be thinking of? Young parents.
That is a
Absolutely,
loaded
that's
question.
That is a
is-
very important question
yeah.
indeed.
Yeah.
You touched on something very important, right? A will is basically a testament. It's
Yeah.
one and the same thing. But very important what you've mentioned is, in the event that both parties, let's say husband and wife, passes away, what will happen to the children?
Yeah.
You know? So you have to make provision in your will for that eventuality.
Yeah.
To say, look, then my mom will be the guardian, etc. But ultimately, it will eventually, you know, boil down to having to litigate and getting the confirmatory orders in
Yeah.
that regard. Also, with regards to the age, you know, there's no limit. You know, if you have anything, I think it's very important these days for us to educate
Yeah.
our children as
Yes.
well, so that, you know, knowledge is power.
Yes.
We also say that, you know, people perish because of a lack of
Lack of
knowledge.
knowledge, yes.
It's so important for us to start engaging our children.
Yeah.
Tell them about life, you know.
Yeah.
They don't learn this in schools, etc. So
Yeah.
the earlier we can have these discussions with our children, obviously the better.
Yeah.
Because they know a lot. Children do. You know, the internet is there. But these important, you know, matters need to be discussed with them.
Yeah,
Yeah.
very
And
true.
when they reach the age of 16, there's obviously certain discussions you need to have with them, or
Yeah.
18. And it's our parents' role to ensure that our children, you know, receive the knowledge and they know how to,
Yeah.
you know, deal with situations.
But would you also say that, and I don't want to labor this one, but if they are minors, do you think they have a say to have Oma taking care of them when the parents are not there? You know?
Yes, so the voice of the child is very important. It's important, you know, to know who will be best for your children.
Yeah.
Ultimately, you know, the children will have a voice also. If they reach a certain age, you know, sometimes 13-year-olds can tell you exactly,
Yeah.
I don't want to go here, I don't want to go there.
Yeah.
Parties may be split up and so forth, but children generally have a say. The courts recognize the fact that their voices must be heard.
Yeah.
Yeah. I wanted to also mention, sorry, Joan, I wanted to mention that I think it starts with conversations.
Yeah.
It's because having a will, it can be a daunting thing just to think
Yes.
about off
Yeah.
the top of your head.
Yeah.
But it has to start with a conversation. You know,
Yeah.
like you might find that in a marriage situation that my ideals are not necessarily my husband's ideals.
Yeah.
And I like the fact that you brought up minor children, is because I'm currently a parent of minor children, and having a conversation with them, that's also how it starts,
Yeah.
is, you know, asking them what do they think is going to happen, and
Yeah.
that they give you the most curious answers. Like my kids, for example, if I'd say, if I die, what do you think will happen? Then
Yeah.
they say, well, we'll just go and live with Opie. You know, it's like standard for them,
Yeah,
you know.
yeah.
And it's interesting that they think that my 66-year-old father will be able to manage, you know, all three of them.
Right.
But yes, the conversations are important. And I'm raising that is because your last will and testament is
Yes.
really the end of the story.
Right.
But what we can focus on it, I think, in a more proactive way is the estate planning. In
Yeah.
other words, you know, how are we organizing our assets?
Yeah.
Yeah.
How are we, in what titles are
Yeah.
we putting
Yes,
it? Because
yes.
that's often, you know, the problems that get picked up is how we lived.
Yes.
You know,
Yes.
do we have a ton of different
Yes,
beneficiaries?
right.
So estate planning, I think, is the place
Very
where we
important.
start
Yeah.
when we
Yeah.
consider
Yeah.
the final
Yeah.
will and testament,
Yeah.
because that's just the execution document.
Absolutely.
Yes.
So.
Yeah.
So that is actually the thing. As I said to you off air, I said I know so many incidents. You know, being in the community field, you know, you tend to see a lot of things happening, and sometimes I was saying to Diane, sometimes you think people are sorted. You
Yeah.
know, they look like
Yes, yes.
everything
They
is
could
in
be.
order.
Yes.
But when they pass on,
Yeah.
Yeah.
then you
There's
find
chaos.
out
Yeah.
that yo,
Yo.
What
nothing
was
is in
going on?
Wheels
order.
are coming off.
Nothing is in
Yes.
order.
Yes,
You understand
yes.
what I'm saying?
Yeah.
So if you can take us through, for the sake of the topic,
Yeah.
how do you draw up a will, right? And with an estate, what do you do, you know, for the people out there,
Yeah.
and for us
Yes,
actually on
yes.
the panel too, who don't maybe know.
Yeah.
What do you do?
Yes, so basically, if anybody wants to make a will, they can decide, do they want to go to a bank where perhaps services are free? There's also Wills Weeks, you know, that is hosted by attorneys where they do pro bono work, and they draw up wills for free for people who are obviously deserving and so forth. So one just needs to, you know, keep your ear on the ground insofar as understanding and knowing when these, you know, pro bono clinics are operational, etc., and then you walk into the pro bono office and you can have your will drawn up. But it's very important for you to know what it is that you have, because you have to discuss, look, I've got X, Y, Z. Do I now specifically put it in the will to say I've got this heirloom, I wanted to go to this person, or do I just say generally 100% of must go to whomever, you know? Everything that I own goes in equal shares to 3 people or 2 people, 50-50, or, you know, 33.33%. So that is the discussion you will have with the expert that you are going to consult with in order to draw your specific will up. Then obviously they will ask certain questions. Are there children, minor children involved? Because if there are minor children involved that you are going to leave, you know, either a specific sum of money to or even assets to, then the whole discussion would come in insofar as a trust is concerned. A trust must be established, a trust in the name of the deceased. We will have a name of the trust, you know, in the document to say, okay, there will be trustees appointed who will then make decisions insofar as the minor's affairs are
But
concerned.
isn't that a very expensive process to have the trust?
Yeah.
Yeah.
Look,
maybe,
it
maybe
is-
draw the distinction between the living will, the living trust, and the testamentary trust.
Yes. So basically, what a trust is, you know, especially if you have property, or there's really a substantial amount and so forth, it's advisable to have a trust. Reason being that a trust has perpetual succession. You know, you can always just update the trust documents as opposed to have to transfer the property now to the children, and then tomorrow there's another estate opened, and then you have to transfer that property to whoever else, you know, needs to inherit and so forth. So it's an ongoing estate and so forth. So the nice thing about a trust is that it has perpetual succession. You make amendments to the trust as you know, things change and so forth. Yes, it is indeed so that a trust is expensive, especially if you don't have substantial assets
Wealth,
and so
yeah.
forth.
Yeah, yeah.
Then you know, the issue is going to come that you know, the trust expenses will then swallow up, you know, the proceeds, etc. But if it's well managed, it can work. So that is ultimately, you know, decisions can be made to sell, you know, the trust assets, and then, you know, the trust you know, doesn't have to, you know, continue perpetually. But yeah.
With regards to the trust, can I just ask a question? Is it important to do it through a company like, Old Mutual, Sanlam,
You would need.
established company?
Look, anybody can,
Or
an attorney firm, or
attorney,
even
okay.
through, yes, these financial institutions and so forth. Look, it's probably by the preference of the person.
Okay.
Maybe I work at the bank and I'm very familiar with, the processes and the people that I would work at the bank, with. So I'd rather prefer to be done through a bank. But ultimately, you can go to any. There's a lot of companies these days.
Yeah.
Where you can actually have your estate planning done through, whether it's accountant or an attorney. As long as it's somebody that really knows what they're doing, it doesn't really matter. As long as your fees, are properly taken care of. But simply by the preference of the person.
Yeah.
Yeah.
So you can create a trust while you live, and you can put all your assets and your things in the trust,
Right.
and then that must be treated as a trust, and it must be administered like a trust.
Yeah.
Or you can, if you, in the case of minor children, once you die, then it's held in trust, and then the children or the beneficiaries
Till
can
a certain
access
age.
Is
can
it
access
monthly?
those.
But it's
Yeah.
controlled by someone, right? By
Yes.
a company or
Yeah, it is.
institution.
Trustees, yes, of that
Trustees,
particular
And
trustees.
you can, the institution itself would have a representative there,
Yes.
and then you can also add on
Whomever
that
you feel.
administration as well.
Yes.
Yes,
So
that's correct.
That would be one way of doing it.
Yeah.
So now, what is the importance of a will?
It's absolutely important because remember we have a lot of blended families. If you don't have a will, it becomes very
Sticky.
problematic.
Yeah.
In the sense that now you have to look at, okay, who are all the beneficiaries, who are the heirs, who are the...
It becomes katarach. I just wanted to say
Yes, and
because it split families.
it does. And also now you need to nominate somebody. And now everybody needs to come together, have a meeting and decide who are we going to nominate ultimately. And that whole process itself can also become quite problematic.
Right.
Yeah.
In the sense that now we don't know who we can trust. We don't know, are we going to do joint, nomination of 2 people, 3 people at the same time? And, we know that trust is always an issue.
So now you're referring to the executor of
Yes.
Yeah.
an intestate,
Yes.
an intestate. So you die intestate when you don't have a will,
Yes.
and that's the katarach that we're talking about right now.
It does
That
become
situation.
katarach because you see, for instance, with us, we were fortunate enough that my parents had wisdom in the whole process, where they called all the children together and they actually read the will.
will.
Yeah,
I
it
love
shouldn't
that.
be
You know
a
what I'm
surprise.
saying?
It shouldn't
I
be
would
a
never
yes.
think so.
It's not a
Secret,
surprise.
yes.
It's not
Yeah.
a surprise. So everybody of my brothers and sisters, we all agreed
Yeah.
on this,
Yes.
Right.
on the will.
Yes.
The house will go for that one, that will do, and you guys
Yeah.
will see to the rest
Yes.
that is left over. So, which means there was no fightings.
There's
Yeah.
no question.
Yeah.
No questions
Yes.
asked. But yet we find that, especially in our communities, you find that people don't have wills, and others who do have wills, right, they don't discuss it with their children.
Yeah.
And that in return becomes a big fight because they don't, some of the family members don't agree. Maybe the elder brother, everything is left
Yeah.
for the youngest brother, or they have the executor, because in a will you have to have an executor
Yeah.
to your will, right?
Right.
And the executor is just the person who's going to
Run
execute
with
the
yes,
things.
yes. And
Execute
obviously
it.
Do the
assist with the signature.
administrative
yes,
work, right?
absolutely.
So maybe
the runarounds.
you can give people tips on
runarounds,
who
right?
should be
Yeah.
the executor
Yeah.
in your
Yeah.
will.
Yes.
Who are we
Yes.
looking at
Yes.
for independent advice?
And what if the executor, like in our case, what if the executor
is a beneficiary?
passed on?
Oh.
Yes, it happens. It happens.
Yeah,
all the
yeah, yeah,
time,
yeah.
yes.
And
Yes,
can I
yeah.
also know, with regards to the executor, why does the executor get paid?
Okay, so let me explain.
It's work, fine.
Must they get paid? I'm just asking for a friend.
Yeah.
Just, yeah.
Yes. Okay. So I'm going to start first and foremost. Something very important came out here that I think I want to touch on is the fact that there's different rules of thought when it comes to a will.
Yeah.
And I love what Joanna said insofar as the discussions with the family, etc.
Yeah.
Now, one must understand that if I want to leave my property to whomever, it's my secret.
It's your your
It's
secret.
my choice. I don't have to tell everybody, but I do understand where that comes from. It's in other regards, or in other respects, it might be very important to do so, because, like for example, I'll use my own example, right? I am a person who believes in fairness.
Yeah.
Right, I believe that, and this is just my own, personal view.
My
Yeah.
thoughts,
That when you have property, and I say I'm going to leave it to charity, for
Yeah.
example, it's my choice. I
Yeah.
can decide if I want to leave it to an organization. I can decide if I want to leave it to my dad or my siblings or to my husband or whomever. It's my choice. But I believe that if decide to leave it to your children in equal shares, it's nice to be able to discuss it with
Yeah,
them.
true.
You know,
Yeah.
and say, look, I have decided I'm going to leave it to you in equal shares. If you
Yeah.
want to do that,
Yeah.
but it's not compulsory. You don't have to necessarily do that.
So there should be transparency, or not? Not necessarily.
necessarily.
It depends.
It's your
It just depends on the
prerogative.
yes. It depends.
You know what I'm thinking of? I'm thinking of this is often a person's last dying drama. Like it's
Yes.
like there's-
Yes.
if you perhaps didn't have good relations with people, you could stick it to people with
Yeah.
using a will. So I think
Yeah.
that could also be one way of doing it.
Yeah.
Absolutely. So, look, the point that I'm trying to basically make, having regard to what was said now, is that, you decide. Do you
Yeah.
want people to know or don't you want people to know?
Right.
And if you do tell everybody, perhaps we'll have a situation, for example, I've got 3 kids. Now I decide I'm only going to leave it to the one kid. Now there's going to be 2 problems.
Right.
Either everybody's going to be happy
Or you're
and
gonna
they're going to be
create a new problem.
satisfied that it's fine. We agree, mom, dad. We also agree with your way of thinking. It's fine. Leave it to the younger sibling.
Yeah.
Or people are going to feel, well, now I'm being inherited.
Yeah.
So no, now there's other feelings that stem
Yes.
from that. So it's a very sensitive thing.
Or
is.
people start, if you think about that, they can also start playing into the will. Depending on how you're going to bequeath the estate,
Yeah.
then they start acting in a certain way.
Yeah.
And you don't want that. You want people to have like a
Genuine, exactly.
relationship and a
Yes.
genuine life.
Precisely.
Yes.
Yeah, so I do see that there are different schools of thoughts. I think it does depend on your context.
Yeah.
I can appreciate your context because it needed to have a conversation because there were many siblings and there were many parties involved.
I mean,
Yeah.
we 8 children, right?
8 children.
And so many
And they needed to
grandchildren.
have that conversation. And there would have been questions afterwards because of the different phases of life that they were in. So I think
Yeah.
it's also got to do with timing. And like you say, it is ultimately your prerogative. And you don't want to sit with friction
Yeah.
while you're
Early.
alive
Yeah.
Yeah.
based on inheritance.
Right.
Yeah.
You don't want to sit with
So
living
true,
frictions like, let's not have this situation.
Right.
I think the larger point that we were alluding to earlier on is that there is a certain, possibly a generation that keeps everything very closed, where it could have alleviated many issues if we had an open conversation about it.
Absolutely.
Yes.
So maybe we don't have to
Yes.
discuss the specifics, but we do have to discuss
Yes.
the fact that I do have a will.
Yeah.
I have considered these things, and
Right.
this is my decision. This is where my will is held. And there are also considerations that should not be put in a will, as I can
Yes.
understand, because
Yeah.
we're talking about the validity of a will. You advise that we should go to an institution, a bank, that we should draw up the will. We have to get the will signed, and then we should inform our family that this is where the will is.
Yeah.
Or a responsible person that you trust. And
Yeah.
Yeah.
that springs to the whole question that you had regarding who do I appoint as an executor? You
Yeah.
know, who's responsible, who's honest, who would
Yes.
Yeah.
really do, the best
would
and,
follow
and
through.
follow
Best,
through
yes.
on the wishes of the deceased, etc. So
Yeah.
it requires a lot of thinking and it requires a little bit of skill as
Yeah.
well as wisdom.
Yeah.
Because
Right.
appointing the wrong person can cause turmoil. Can
Yes.
cause
Is it
other
drama of
issues
its own?
exactly.
Yeah.
Yes.
Yeah.
Yes.
And in the case of children, you do have to, while you're alive, speak to somebody and say, I would like you to take responsibility for my
Yes.
kids.
Absolutely.
Because that's not a surprise that you want to find out when, the
Yes,
parent dies.
yes,
You don't
yes,
want to, it's
yes.
you, it's all on you.
Right.
And, and that conversation can also be more sensible if you think about, they have to accept that they are the ones going to be appointed to take care of your
Yes,
kids.
right.
Yes.
And you also have to maybe outline what that scope of responsibility looks like. And I
Indeed,
think
so.
it's perhaps gracious of you to provide something for the person that
Absolutely.
is
Yeah.
meant to take care of you. And all those things can sit in a will.
Yes, and
All
I
of
also
that.
think there's you have to look at the characteristics of the executor,
Yeah.
because I think that's very important. It's vital due to the fact that you find such a lot of corruption happening
Yeah.
in today's life.
And fraud,
and
specific
fraud,
fraud,
and
yeah.
fraud,
Wow.
Yeah.
because
Yes.
people can sell your house without you knowing.
Yes.
That's how people operate in
That's so
today's
true.
life. You know what
Yeah.
I'm saying?
Yeah.
So it is important to look at the character of the executor in what type of person
Yeah.
it is. You know what I'm saying? Is it a person of integrity? Is it a person who's fair? A fair person who will be able to see that whatever the wishes of the deceased were, that I will fulfill it. You know what I'm
Absolutely,
saying?
yes.
I think that is so important.
Yeah.
Maybe we can speak about separating that kind of power, because you don't want to leave it to one person unchecked. So oftentimes institutions can give us like a three-pronged approach where you need a sign-off basically of three people, because you never know what can happen in life, in the sense
Yeah.
that
Yeah, because
you
you-
give
Yes,
all
what
this
if-
person
Yes,
and
what
they're
if
in
the
a
person
bad
that you
situation.
appointed as an executor dies?
Yes.
Yeah,
for
when,
you.
when the executor dies, come I tell you personally, our situation. The will of my mum, when my father passed on, my mum had to amend the will, right? Which was the right thing to do.
Yeah.
And then she made my elder brother, my eldest brother,
Yes.
the executor. And the second of the executor, can I say the second person,
Yeah.
was my elder sister. They both died in a jiffy, 3 weeks after each other, like that.
Yeah.
All
Which
of a
gets to the
sudden.
point, yes.
Yeah.
These things can happen. So
happen.
ultimately, in a situation like that, if that were to happen, you would now need to get the death certificate, inform the master, that this has happened, the persons are no longer there, then you need to nominate somebody else,
Okay.
or get an attorney appointed, but that comes with all sorts of other paperwork and
Yes.
it's a lengthy process.
And
It's
expenses as
bond of
well.
security that's needed. Remember, if you appoint an executor or 2 or 3 executors, in the event of, one not being available or not wanting to take up appointments, you always make provisos in the will itself, to just, cater for those instances where somebody could pass away, and obviously updating your will accordingly if anything happens. That's what people, tend to procrastinate on. But also important is that there are ways to deal with situations like
Right.
that. Yes, and it can be cured. So on the issue of, I also, the question regarding the remuneration, I think it's a very important and good question.
Yeah.
Yes, yes.
Regarding that, if you are a professional and you're an executor, you're entitled to remuneration.
Okay.
But there's a difference between the remuneration of an executor.
But
'Cause
where
remun-
does the remuneration comes from? Is it from the estate itself, the property that's being sold, or?
Yeah, so basically, if you appoint an attorney to be the executor of the estate, or let's say you go to a bank and the bank is the executor ultimately, because of the professionalism and being a professional appointed executor, you're entitled to more than just the 3.5%. You can also now say, well, I'm entitled to my professional fees in respect of having to sign off documents and that responsibility that goes with an executor, but.
Right.
Such a person doesn't need to be appointed. It can be a family member.
There are
Then there's
also
no-
tariffs, I believe, though, or
Yes.
ceiling. What is the ceiling? Is it like 27%, the maximum amount that an executor can take off?
Yes, so generally, if you're going to an institution like, for example, a financial institution, it will generally be like 10%. You can work it out to 10%. Remember, they charge VAT.
Yeah.
Other attorneys, don't charge VAT. Depends on, obviously requirements and so forth that are met. But fact of the matter is, you get an attorney that either is registered for VAT or not, then you won't pay VAT. If the person is not registered. But generally the institutions, they are registered for VAT, so there will be a VAT, added on. It's always either, still VAT to be added, or, there's no VAT applicable. But generally about 10% you can budget for if it's a financial institution. But if the executor is not a professional, it's normally 3.5%. So if your family member is going to do the bit of the runarounds, come in, instructed by the administrator of the estate. Remember, the attorney is basically the administrator of the estate.
Okay.
And then you have an executor appointed, which can either be the attorney or it can be a responsible family member. And then ultimately, there's no remuneration that becomes applicable. But, if that person is a professional, then obviously professional fees will come into play.
Tell me, Diane, so, let's say there was a will and everything. And so the property is now left to a person. With COVID, people died suddenly.
Yeah.
Some people died without a will, right? So I know of someone that, died without a will, but they were married in community of property. So the property came to the spouse. But now the spouse doesn't have the money to put the property on her name. So what happens in a case like that? Or is it something that you can be prepared for, or that people should discuss as well? Like when we do planning, because what's the use, when the one person falls away and the other, and you can't even get so you just have shelter.
It has often been quite a big surprise for people that they actually have to pay to inherit. It's like inheritance costs money.
Yes.
And
Comes with responsibility.
and that's what we can think about when we're drafting our wills and we're doing our estate planning, because it costs money to inherit, because you have to pay for the transfers, and oftentimes people don't have that kind of available funds.
Absolutely.
And I see that, and it's very useful, I might say that in drafting, if you speak to an estate planner now, in drafting a will, they have a new policy now that makes provision
For the costs.
the costs of
The winding
bequeathing your
Yes.
your assets and the winding up of your estate. And I thought that was just in concept. I thought that was so crazy.
Yeah.
You have to pay so that someone can inherit and it won't be a burden. And
Can you believe it?
and
Yeah.
imagine
Your
you
own
can't
stuff.
afford to inherit something because you can't afford to pay
for
the
it.
administration,
Then you
and then
really-
you lose the thing that you were
Everything.
going to
Yeah.
inherit.
And where does it go to
Yes,
at the end of the day?
and it goes back to the
nobody.
system.
Yeah.
To the system.
It just
Nobody-
lies there
it's-
unattended.
Yeah.
So that is such an important, question and a discussion and a point that was brought up, because that is what is happening in our communities as well.
Right.
Yeah.
Yeah.
They are not informed of the fact that, I can perhaps have like it boils down to a funeral policy.
Yeah.
You have a funeral policy. Same thing with your winding up of your estate. You can now take out a policy, pay a monthly fee, and then ultimately that policy will kick in the event of death, and then pay all these administration expenses.
Right.
So it becomes quite costly.
Yeah.
Yes.
The other thing I want to
But
that's
yes, you can get a policy that can help you.
you can get a policy
yes,
to help.
you inherit.
I like
Yes, or at least pay for the expenses
Yes.
incidental to the winding up process. Like,
Yeah.
Yeah.
to explain that, right? Let's say you have a property valued at 500,000, just a simple example. If you times that by 3.5%, because that's the administration remuneration to the attorney that, is obviously going to go to the attorney for all the, work that needs to be
The
done,
admin.
and so forth. So 3.5% of 500,000, if my mathematics is correct, it's probably 15,000 some odd, maybe 500 if my maths is
Wow.
correct, But in addition to that, you also need to pay the master's fees.
Right.
It starts at 600 or, depending on the value of the property, and there's a specific tariff that we work with. You have to pay for 2 advertisements, which is 500 Rand each. The first advertisement is to call upon all creditors to lodge, claims against the estate. In addition thereto, you have the transfer costs. So let's say,
The transfer cost is usually the
Yes.
one that kills
that's
people.
a question I was
Precisely,
going to ask about the
yes.
creditors.
indeed so.
Because the creditors, if you have debt, as the person that passed
Yes.
on, then it must be paid from the estate. Am I right?
Yes.
Indeed, so sometimes you can't transfer the property into your name because either there's a bank and you don't have, the means in order to pay because perhaps the person who's deceased didn't think of taking out life insurance,
yeah.
to cover the bond in the
Yeah.
event of death. So all these things can become problematic, especially if you're married in community or property, because remember, you might be a housewife,
Yeah.
and now all these policies are not in place.
Right.
You can't, now you have to sell the property because you have to, make good with the bank or whatever creditors, and then only possibly receive, a minimum out after all has been paid. We have municipals that needs to be
Yeah.
brought up to date. You have clearance figures, from the municipality.
And you have
There's
to
so
transfer
much,
that onto
exactly.
your name as well. Yeah, it's a lot
Sure,
of
it's
work.
a
That's
lot
why
of-
it's
a
not
lot of
it's
work
not just
and
about
a
the
lot
wallet,
of
it's about
money.
how you live, in
Work.
fact.
So, but what is the policy called? Is it just a policy that you can say, okay,
It
this is
called
toward
something.
the, what is it called?
Like there is certain...
Because I think it's very important that,
is.
especially if you have buildings, if you have properties,
Yeah.
you know what
Yes.
I'm saying? I
Yes.
think it's important then to have then the policy who
Yes.
will that will kick in when you're not there.
Yes.
Almost like a fund, a
Yeah.
bulk
insurance,
of money.
like
Yeah.
insurance, policy. Like if my car's in an accident, I will just pay, whatever I need to pay in terms of my access, and then the policy will kick in and fix my car, etc. Same principle
Okay.
applies.
That
But
is
even with
wonderful.
regards to your credit cards, your debts that you have, you need to have a life insurance,
That
life
is
cover
it.
on it.
On your vehicles as well.
On your vehicle,
Make
on
sure there's
your
life
credit
cover.
card, on your
And
your
on your
account,
bond.
And maybe
whatever.
don't duplicate
So
that, because many of the institutions now, like your credit
Yeah.
card, for example,
They
they'll
add
call you and they
everything.
offer,
Yeah.
And then so you have a
Yeah.
life insurance, and then
Yeah.
you have all those other insurances. So
Yeah.
maybe don't duplicate that.
Okay.
Because
Just
it's-
check it.
Yeah.
Yeah.
Just check that you're
Yeah.
covered, and it covers all those
Yeah.
other.
Those
Right.
expenses, yeah.
Yeah.
Yeah, because I
expenses.
think that's vital, Because for the
is.
people
That are
who's
behi-
going to deal,
yes,
who's staying behind,
behind.
for them to deal with it. And that
Yeah.
is why I love the conversation part of it.
Yeah.
And that is why I prefer that, to
Yes.
be quite honest,
Yes.
to call the children,
Yes.
tell them this is the executor of mum and daddy's will, and this is how we split it up, and,
Yes.
and things like that. So, like for us, we have to have a will.
Yeah.
There's no two ways about it. We have to.
Yeah.
So
Yeah.
I just want to go to these in case we gonna carry
Yeah.
on and
Yeah.
forget about the people. There's a question: can you incorporate assets in your will that is part of a divorce settlement agreement?
Oh, like,
That is a good question.
but no, let's get the clarity. Assets in the will, can
Yeah.
you incorporate it?
Can you incorporate the assets in the will?
Yeah, as part of a divorce settlement.
Yeah.
as part.
Yeah,
No,
so
in your will, that is part of a divorce settlement agreement.
Okay, so basically how it works is if you get divorced, there's either a court order that says division of the joint estate if you're married in community of property, or you have a settlement agreement that the two parties will then conclude, and you will say how these assets must be dealt with. Now, I think I know where the question is going, or where it's headed towards, but generally the rule of thought is always, as far as a will is concerned, it's a separate document. Your settlement in your divorce has to do with your divorce.
Okay.
So if I, for example, am getting the house, my husband is forfeiting the house in my favor, which means the house belongs to me. I now obviously have to go and do the transfer in the deeds office to reflect the endorsement insofar as the forfeiture is concerned. So there's a whole lot of steps that needs to be followed. Once those steps are followed and that house now belongs to me, I can now deal with that house in a will. But if, for example, a divorce settlement says, well, I need to pay my husband out 50%, then you need to pay him out. And you need to now do the transfer in the deeds office to show that, I've substituted him as debtor with the bank, and furthermore, I'm now the 100% owner, and I've paid him out, then you can deal with it. But if I'm only owning 50% of the house, and now it's the divorce, etc., you know, those matters will be dealt with in the divorce. But ultimately, when everything is finalized, all the steps have been, you know, complied with, and you know, you've done what you needed to do,
Two separate things.
then you deal with your asset, which you now have acquired in the divorce, and then you do your will.
Right.
And then similarly, on that same thing, just before we go on to our next question, can you exclude, if you inherited something, you inherited your house, Joan, and now you want to exclude it from a divorce because that forms part of your estate. How do people do that?
I see it.
In
Okay,
other words, it doesn't fall into your
Yeah,
estate.
yeah.
It's excluded from that.
Okay, so there's many ways of doing that. It depends on how you get married. If you get married in community of property, it's in community of property, you know. But
So, in community property, please explain.
it's basically 50-50. You get married.
Yeah.
So, you know, if I get married today and I have a house, my husband will then automatically, by virtue of the marriage regime, be entitled to 50% of that
Right.
particular property. Now, if you are going to make a will, for example, you can say, let's say my mom is leaving me an asset, or, you know, the house that she owns. Then in the will, you can say that the inheritance will exclude any marital regime in community. You understand? So you can
So
exclude
you
that.
have to mention
So
it.
you can do that.
You can do that in the will itself. And also other people get married out of community without the accrual, or with the accrual, then obviously donations and, you know, everything else, like, for example, inheritance and all that would generally. But that's how you draw up your ANC contract again. You understand? So generally you can decide how these things are going to.
Can people
Play out.
contest a will?
Yes,
Yeah,
you
they
can
can.
contest.
And that's why a valid will is important.
Yeah.
Yes, for
Yeah,
example,
that's what we
there's a
were.
thumbprint.
Yeah. We were talking about that. Some
Yes.
people go to CNA and they go thingikie and they.
I-
Yeah.
What's
Je
your-
moet
what's
aan
the
die
word
tafel
on the
praat.
CNA
You know
will?
what I'm saying?
Praat, sister.
The
You know the
baby
problem?
mama dramas and all of that. Now you find out you did, and you have a
Another
son
child.
and a
Yes, and they come forward, and now
everybody
there's
comes
paternity and
forward.
DNA testing that needs to be done. I've had
Yeah.
all scenarios.
Really?
So you can ask me any question relating to deceased estates, and I will
Yeah.
tell you stories
Wow.
that you will have had nightmares for the rest of your life. But anyways, exactly, all these points that have been brought up is so essential. A
Yeah.
will, you go to the CNI and you decide you're going to magically fill in this will on behalf of somebody, and one wrong move, that will goes to the master, and they automatically reject it.
And then they
as
fall
there being
into
no
intestate.
intestate succession. Yes.
Okay.
So, there's certain requirements that need to be met before a will be regarded as valid. And one wrong move, seriously, dead in the water.
Okay, so don't do CNA hashtag.
Okay,
There's
that's a
another
will.
Tennille Alexander. Joan asks, can guardians also be appointed or nominated in a will?
Yes, you can.
And then just to piggyback on that, I also want to, while you answer that question, there are things that we should put in a will and things that we shouldn't put in a will.
Right.
oh, yes.
Like,
I can think of something.
so let's answer Tennille's question and then just add on what shouldn't be in a will and what should be in a will.
You know what? I have this thing, and it's just my personal opinion.
Yeah.
That, yes, a guardianship, you can always just say that, in the event that anything happens to me, these are the people that I nominate as my guardians.
Yeah.
For the minor children, etc., etc. And that's always advisable to do that. To have discussions with them, like you've mentioned, Leanne. Furthermore, you've also said that make provision for your children ultimately.
yeah.
But in the event of any dispute, obviously the matter will go to court, and the court can make a decision regarding that. But something that I realize our older generation, shall I call it our senior citizens?
Yeah.
Okay, yes. So what they normally do is we say, no, we want this house to be a family house.
Yeah.
Yeah,
That
yeah.
is a
There's
thing.
so
That
much
is a
drama.
thing.
Very.
Yeah.
Okay.
Yeah.
What is the
A lot of
drama that we
drama.
should look out
A
for?
lot of drama.
Think about it. If I have got a house and I've got 100 children or 10 children, can you imagine saying this must be a family house?
Yeah.
How is it going to be
Who's gonna
practically?
take
Who's
care
gonna
of
be
the
responsible for the
maintenance?
family?
Yeah.
Who's
Who's
going to
the
live
rates and the
there?
taxes?
Who's going to pay the rates?
Yeah.
Are we going to draw up? Then we have to draw up other agreements.
Yeah.
And people don't do that, and that's where the disputes come in, and then we end up in, what is it called? Room 6. That's
Yeah.
what Kliptown is famous for. Everybody knows they're going to room 6
Yeah.
because then this one is fighting with that one. It becomes domestic violence. It becomes
Yeah.
a big issue, and then they're all in court.
Right.
Yeah.
So generally, what normally works is, and people don't like to hear this, if there's a house, why don't you just sell it, split it equally?
Yeah.
You know, or
Fully
buy the
agree.
one, buy the other one out, or
Yeah.
put it in a trust
Fully
and
agree.
have an agreement to regulate the relationship insofar as, you know, this property is concerned. Like a company, think about it. If you have,
Or you should actually find out if that's your heart intention, because it really is a good intention to have in your heart.
very good intention.
You should
yes.
actually find out if your family wants to do that. Do you know what I mean?
Precisely,
Because
yes.
it can be a good intention, but then you
Yeah.
find out there's actually no appetite for. I'll put that again. Must you
Yeah,
start that
let's
again?
start that again.
Okay. You can just say whether we're on or not.
I think.
All right, we are so sorry about that, beloved. We had a power failure, so yes, we're back online. The generator kicked in, so yeah, we're back online again. So thank you so much for your patience, and I know you were wondering what is happening now. We can't hear you. Sound. That is fine. We're back. So there's quite important things that we actually also want to discuss quickly, and I'm going to ask Leanne just to ask that question again.
Before you guys left us, we were having a chat about there are things that fall within an estate, and there are things that fall outside of an estate. And I think it's important that we perhaps create a differentiation of what falls in and what falls out. If it falls out, as soon as you die, those policies can be executed, but something that falls within an estate will have to go through the estate administration, and very often that's a lot of time. So help our listeners understand what are those categories.
Okay, so let's say, for example, you have a pension fund. You know, let's say you're a teacher, you're a principal. Simple example is everybody knows government, a pension fund, the GPF, right?
Yeah.
Generally, for any pension fund, you would have a beneficiary. So if there's a beneficiary, all you do is you fill out the necessary forms in the event of someone's passing. You might need a letter of executorship or authority. In addition thereto, you can fill out the forms and then just submit it to the fund, and it will be paid out directly to the beneficiaries.
Yeah.
What people also don't know is when there are children, obviously if there's beneficiaries and there's children involved, the children always get preference. Children get preference over any adult because obviously they're much more needier. If, for example, mommy dies or dad dies, then there's children perhaps, and obviously the trust and the funds need to look after the children because, you know, the children's needs are always of paramount importance. So then that doesn't fall in the estate itself. But what I always say is that you can always choose your beneficiaries, but you can leave a portion to be paid out to your deceased estate for the simple reason that you want to assist, you know, with the costs incidental to the winding up process so that you don't burden your beneficiaries. So I made the example earlier. I said, I am a professional, you know,
Yeah.
we have professional, cover and so forth for doctors and lawyers. So in my life policy, I can obviously choose my beneficiaries. But what you can also do, you can say 20% will go to this person, 25% will go there, but at 10% I want specifically to be paid out to my deceased estate, which will go into my deceased estate bank account when it's ultimately opened to assist with the actual administration. So there's many ways in order to, you know, alleviate the burden and also to create practical solutions for all these, practical difficulties that we've heard of and we've seen and so forth. So there's always
and that's
a solution.
also an answer to your earlier question, Vi.
Yeah.
About if you don't have the policy to cover those administration costs, you can bequeath a portion
Right,
of
of your-
an amount that falls outside of the estate to be put back into the estate
I like
Yes.
that.
to
one.
facilitate
Like a life
that.
policy,
Yes.
yes.
Yeah.
Yes.
Yeah, that's
Absolutely.
actually very
That's a
good.
That's
good-
very helpful.
to know.
very
I didn't
helpful.
If I
also
can
know
just
that.
ask the question from one of the ladies, Gail. Gail's asking, does a will override the marital regime?
You answered that briefly earlier on.
Yes.
Yes.
If it's bequeathed.
Yeah, look, ultimately, if I'm married in community of property, technically, if it's a happy marriage, there will be a joint will.
Yeah.
But sometimes along the way, people become distant. There's maybe some acrimony between the parties, although they're still married. Then that person can decide, no, I don't want to make a joint will. I want to make my own will. Doesn't have to be joint. My husband doesn't need to know. So now I say, if I'm married in community of property, how it normally works is 50% belongs to the person.
Yeah, in any
and then
event.
obviously, if the person passes away, then it works like this. I already own 50%, but now we need to deal with the other 50%. As a married spouse in community of property, I'm entitled to my 50% plus 250,000 or child share, whichever is the greater. Now that's very technical. Let me try and make that simple.
You own half and the rest go to the children, and you can inherit part of that as well.
Indeed so. Exactly that. So what if I need to make an example? Let's say the house is valued at 300,000 rand, right? 150,000 you can't touch. But now there's 150,000 rand left. Is the 150,000 I'm actually entitled to 250 also as a spouse, but there's only 150. So is there going to be a child share? No, because I'm actually getting out less. I'm supposed to get 250 or a child share, and then I'm going to get the full 150. There won't be a child share applicable. That's intestate. All right. So if you're going to make a will and you're married in community, then you can only deal with your 50%. Then you can say, well, I want to now leave my 50% to my child. And that's where you exclude your spouse in the community of property of the 250 that he would have been entitled to or child share, in community of property. So the will would eliminate that issue where you don't want your spouse to get 50% plus 250, if that makes sense.
Now tell me, if there's no will,
Yes.
right, and someone passed on, okay, and for instance, there's a house, right, and the children are still living in the house. What happened in a case like that? Can the children still then, if the father's still alive and he moves on with his life, can the children still get the 50% and the husband the 50?
It just depends on, I always say that you can always contract outside what needs to happen. But generally, if there's no will, intestate kicks in. So technically, the spouse
Estate has to
married,
be wound up.
the estate married in community basically would benefit more than anyone else.
Yeah.
There's a lot of protection to spouses in community of property. And if the value is large, then obviously the child would have entitlement to a child's portion, So you work it out as such. You say, well, let's say 50% is equal to R1 million, right? Now you have got R1 million, okay, fine.
And 5 kids.
So the 500,000, for example, would go to spouse if the house is R1 million.
Right.
Is
Now
that
there's
without a will, ne?
Yeah.
Now there's another 500,000 for argument's sake left, right?
Yeah.
Now you look at it now. You calculate the 500,000 that the spouse must share and the child. So you simply divide it by the spouse, 1, and the amount of children. Let's say there's 3 children. You
Yeah.
divide the 500,000
Yeah.
divided by 4.
Amongst that,
You
yeah.
understand? So if the 250,000 rand, and you compare it with the child share, if you divide it, if the child share is more, then obviously the bigger amount the spouse gets. So it's you get 250,000 rand or a child share, whichever is the greater. If the child share is greater, spouse gets greater. But if the 250,000 is greater, he gets the 250,000 and the balance goes to the children.
Okay.
But it might not also, I'm just thinking about a living situation. So you're saying that the person died, the wife died, or
Yeah.
the spouse died,
the spouse died, yeah.
and the husband lives in the house with the children. They would probably stay in the house.
It depends on how the father, I mean, I don't think
And
the
then-
father would put the children out.
Yes,
but
because he's responsible for them.
Right.
So they could stay in
Yes.
the house. And because I'm thinking, oftentimes children's portions get lost in time and in other responsibilities. So it can happen if you do such a thing, that they would just end up living there, and then only when the second parent dies, then they would only be able to kind of inherit.
Yes, provided there's a will, or then they'll just inherit intestate. But back to the point of what will happen to them living in the house now. Obviously, I don't think a father would put a child out, but you never know if the father's going to get married
Unless
again.
it's an adult child.
Yes, yes. So if there's an adult child, or
Then they
if-
gotta go.
They gotta go.
you could be that, or dad would say, no, you guys are going to live here, I'm not going to. Maybe
Move
finds
on.
moves on with his life.
Yeah.
Then he brings his new
Yeah.
person into the house.
Yes, and I think
now
that's
there's
what-
conflict
Yeah.
because
Yeah.
there's a whole issue sometimes there. Either you're going to accept the new person or you're not going to. Then people are going to be there's going to be that acrimonious situation. People are going to want to move out. So different scenarios for for different.
But just another
situations.
case that you
Yeah.
have to have a will. You just have to have a will.
It's much better
because
It's better, yeah.
if you're
it's
worried
better.
about your kids, that's
So thank you so much, Roy Skulls, for tuning in. There's another question. If you leave a sibling deliberately out of the will, can it be contested?
Look, like I said, it goes back to what I've said. You have a choice. If I don't want to, if my child is now suddenly, in a specific, maybe he's done something that I don't approve of, I decide no, but I'm going to exclude you for whatever reason. It's my choice. It's my property. So I
What
can
is
decide.
what are the to ask that same question differently? What are the grounds of contestation? On what grounds can
Yes.
a will legitimately
Be contested.
contested?
Let's say, for example, the
time up,
thumbprint is the thumbprint, or you say that is not the person's signature. Then you alleges must prove
So signature.
signature, or then you have to go to court, and the court needs to then give the ultimate order that this will wasn't compliant and so forth. Other things also, if I have dementia. You understand? Or I've got, I'm not of sound mind, then I can't make a will. And if the person signs that will or is influenced in such a manner to do such a will, then I can obviously dispute it on that basis.
So the date would also be important.
Very
Yes.
important.
Like
yes.
if you were sane and you drafted the will.
The
Yes.
will.
Or
when
you were-
ill.
Wow, that is important.
And if you're
Out of
disputing the
sound mind.
signature, obviously you'll need something that the person signed at some point, recently on another document to show. But and then obviously the handwriting experts would come in to ascertain whether that signature is in fact
And
valid.
undue influence, does that still play a role in that kind of thing? Like, for example, if you got a new squeeze and, let's use the typical example of an old man and a new squeeze. And, now all of a sudden everyone's disinherited.
Yeah,
And
yeah.
is that
Yeah.
valid at all? Or do we only see that in movies?
You know what? At the end of the day, as long as the will is compliant,
Is it?
you're going to have to eventually attack the veracity thereof, and you're going to have to come up with a sound reason as to why you believe. If you say, well, there was undue influence, okay, you're going to say there was a gun. How are you going to prove that there was a gun to the person's head?
Yeah.
You understand all those things, but also we all know our parents' signatures and so forth. And if somebody would have obviously tampered, you would know that.
Yeah.
Okay, now I need to get the handwriting expert or so. But undue influence, I always say, nobody holds a gun to your head to sign a document. That the burden of proof is going to be quite a bit hectic to prove that.
Yeah, so it becomes complicated.
Yes,
To
yes.
contest.
And
Yeah.
then costly as well, because the High Court will need to be approached.
Yeah.
And you don't go to court on a hunch, you go to court on facts.
Yeah.
And if it's factual basis for what you are alleging, then yes, probably a competent court could assist you.
Yay, beloved, we came to the end of the show. Very interesting and very, very, very intriguing, really. I was in it, totally in it, and I know you were in it because I can see of the amount of people that we had online. So thank you so much for tuning in. We definitely will go for another part 2 on this, so we will let you know that is why it is important to subscribe, so you can know, so hit that bell, guys, and subscribe to the Inside Show so that you can know when Advocate Diane will be back.
Yeah.
So if you're really interested in this topic, give us a thumbs up and so on and so on. We love you. And we just want to say short and sweet, guys, because our time is up. Just say goodbye to everybody. And that's it.
Hi, goodbye, everyone. I hope and trust that you found the topic that we discussed this morning as interesting and as important as I did, personally. I just want to urge you, if you haven't looked into, drawing up a will or testament, that you do so as soon as possible. ASAP.
I'm going to quote Pastor Joan, and she says, don't buy-za. So just do it.
Just
And
do it.
there's another quote that says, never say you know a man until you have shared an inheritance with him. I think it's just wisdom to do it. Just get it done.
Yeah.
Evaluate your life. life is, we get life every day, but tomorrow is not promised to anyone. So
Right.
just have wisdom. And thank you so much, Diane. It was just great.
It's a
Yeah,
pleasure, but thank
thank
you
you.
so much for everybody that tuned in. Thank you so much for your participation.
Yeah.
You know what? It really helps tremendously. And also very informative as well. I'm sure that everybody, is enlightened, and obviously they have, seen the importance and that
Yeah.
time is of the essence. And most importantly, that they're going to go now and consider all of these
Right.
things.
Well, I want to thank you so much for coming, Diane. Thank you very much for your time and the effort. And I know we can ask you any question. You know it off by
Yeah.
heart.
Too long in practice.
Yeah, true. Thank you so much to my girlfriends being on the show every week. I really, truly do appreciate everybody who tuned in this morning. We love you. God loves you best. Go in the peace of the Lord. Mwah.
Bye-bye.
As